what's worse is that the prosecution request was upheld, or that decision was upheld on appeal. What I'd like to do is focus now on three features of that decision. Time precludes me from going into any more detail, I'm afraid, but there are three issues that I believe are key to understanding where the defendants accused of the most serious crimes can receive a fair trial before the courts of Rwanda. Well, the first issue is this. It's the way in which the Chamber dealt with the conflicting ways in which the prosecution and the defence approached the question of whether a defendant could receive a fair trial in Rwanda. The prosecution's position was this. It said that the law in Rwanda, the text of the laws in Rwanda, provided the necessary guarantees. And that was enough. That was all the referral chamber had to consider. That's all the referral chamber had to concern itself with. Our position was perhaps a little more nuanced, and it was to argue, firstly, that in many cases the texts themselves left a great deal to be desired in terms of how an accused person's fair trial rights would be protected in law. I'll come back to one example in a moment. But secondly, and perhaps more importantly, our position was that whatever may be provided for in the black letter law, the reality on the ground was really very different indeed, that there was a gulf between what was provided for in the law and what the reality was. And our position was that the evidence shows that the law simply is not respected in the courts in Rwanda. To that end, we relied very heavily on a Human Rights Watch report that I'm sure many of you will be familiar with from July 2008 called Law and Reality, Progress in Judicial Reform in Rwanda. So the title gives you a hint as to what the report was all about, Law and Reality. If you're not familiar with the report, I'd urge you to look it up on the internet and read it. It's now some 4 years old, but in my opinion it is just as valid an analysis of the realities of how the law works in Rwanda today as it was back in 2008. The report contained quotes, transcripts from many sources, most of which were necessarily anonymized. For example, and it echoes something that Dr. Rudasingwa said a moment ago. There was an example of a Rwandan judge telling a Human Rights Watch researcher, we have beautiful laws, among the best in the world, but they are not obeyed. Another quote comes from a former police officer who said, when asked to assess the effectiveness of recent reforms, he said this to the Human Rights Watch reporter, you can't understand, you see what's on paper, but you don't know the truth. You foreigners are easily tricked. Well, how did the referral chamber navigate a way between these different positions? Well, I believe that it navigated its way by fudging the issue. The chamber, in fact, expresses throughout its decision, this is the first instance chamber, throughout the judgment about certain features of the prosecution requests. And one example of the concern that the referral chamber raised relates to Article 59 of the Rwandan Code of Criminal Procedure, which, forgive me, but provides as follows. Persons against whom the prosecution has evidence to suspect that they were involved in the commission of an offence cannot be heard as witnesses. We argued, amongst other things, that this leaves it effectively in the hands of the prosecutor in Rwanda to determine which defence witnesses the defence can call. the Kigali Bar Association intervened as an amicus curiae and said, in practice, a suspect can be heard as a court informer, but anything that he or she says would have to be corroborated by other evidence. So you see how fundamental a problem this would be to a defence team trying to represent an accused person. I'm going to repeat what Article 59 says. Persons against whom the prosecutor has evidence to suspect that they were involved in the commission of an offence cannot be heard as witnesses. In the prosecutor's response to our reply, there was, well, the prosecution didn't deal with that point at all. They ignored it completely. So difficult a point it was to answer. To be fair, the referral chamber itself recognises what a huge problem this is. And there were 5 reasons why the referral chamber considered this article, Article 59, to be problematic. Firstly, it wasn't clear whether that provision would permit the accused to testify in his own defence. Secondly, as the provision allows the exclusion of a witness's evidence on the suspicion of the prosecutor rather than on some legal ground, it violates the principle of the presumption of innocence. The referral chamber says this in terms. Thirdly, the chamber noted that the law provides no indication that a judge can overrule the prosecutor's indication that a witness may be guilty of an offence. Fourthly, the law didn't specify what type of offence might warrant exclusion of a witness giving sworn evidence. And fifthly, because this provision could be applied in an arbitrary manner by the prosecutor, it could have a chilling effect on the willingness of potential defence witnesses to testify. Now, bearing in mind that what the test for transfer to Rwanda within the ICTR's rules is, the test is the trial chamber shall satisfy itself that the accused will receive a fair trial in the courts of Rwanda. That's the test that has to be overcome by the prosecutor before transfer can take place. Bearing in mind that test, you may think that on the Article 59 point alone, the prosecutor's application would fail. How can, I ask rhetorically, how can a referral chamber be satisfied that a person will receive a fair trial given these concerns? Not whether it's possible that an accused would receive a fair trial, not even whether it's probable that an accused would receive a fair trial in Rwanda, but how can a chamber be satisfied that an accused will receive a fair trial? This is just one of many concerns that the referral chamber had in its judgment. And as I say, time precludes me from going into more detail. What the chamber did in getting around this problem in what I believe to be a pretty intellectually dishonest way is to rely on the safety net of the monitoring and revocation mechanisms that the ICTR rules provide for.